He has been on probation for evading arrest, detention with a vehicle. He was on probation for DWI in 2002. 2004, he was placed on DWI second probation for 2 years. He was sentenced to 6 months in jail for assault bodily injury in 2003. 2024, he was charged with escape.
Welcome to the Court of Justice.
It's calling 2024 CR 008-620, State versus Joshua Parau. Can I have parties announced for the record?
Lastly, Sacramento District, Mr. Pardo. Mr. Edelman's for the state.
All right, for the state. And are you Mr. Pardo? All right, you entered a plea on October 17th. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years, and the state is silent on your recommendation for probation. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Your Honor.
Any objections to the PSI report, state? Defense?
And,
Have both parties reviewed the TAP evaluation?
yes, we have.
Any objections to the TAP evaluation, state? Defense?
No, Your Honor.
Any witnesses?
No.
Defense?
No, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He has been able to gain gainful employment. It starts Friday, and it's the back caver roads. Over on Goldfield Road. He has never been on probation before for a felony.
I'm sorry, what?
He's never been on probation before. According to the.
No, I mean, I'll let him finish because I'm looking at I see
Oh,
the,
okay, I was basing, if I'm mistaken, then, I apologize. I was basing it based on what my client. So I'll withdraw that part.
all right, so what I can tell you is he has been on probation for evading arrest, detention with a vehicle for 6 months, deferred adjudication. A motion to revoke was filed. It was withdrawn and the case was dismissed. He was on probation for DWI in 2002. Probation was revoked and he was sentenced to 4 months in jail. He was sentenced to 6 months in jail for assault bodily injury in 2003. And also in 2003, 6 months in jail for interference with emergency telephone call. 2004, he was placed on DWI second probation for 2 years. His probation was revoked and he was sentenced to 6 months and 20 days in jail. 2004, he had a criminal mischief, $500 to $1,500. He was given 2 years probation. A motion to revoke was filed. The motion was granted. He was sentenced to 6 months and 20 years. 2024, he was charged with escape. He was given 2 years probation. A motion to revoke was filed. Motion was revoked. He was sentenced to 6 months and 20 days in jail. 2006, he was sentenced for assault bodily injury married to 4 months and 20 days in jail. 2008, assault bodily injury. The offense was reduced and he was sentenced to 60 days in jail. 2009, violation bond or protective order. He was placed on probation and MTR was filed. Probation was revoked. He was sentenced to 7 months and 20 days. 2010, violation bond protective order, 56 days jail. 2014, assault bodily injury. That was a felony. It was reduced to misdemeanor. He was sentenced to 1 year in jail. 2017, assault bodily injury family household, 5 months jail. 2019, criminal mischief, $750 to $2,500. He was placed on probation for 1 year. A motion to revoke was filed. Probation was revoked. He was sentenced to 90 days in jail. 2023, criminal mischief, $750 to $2,500. He was sentenced to 10 days in jail. 2024, terroristic threat causing fear, 80 days in jail. 2005, evading arrest, detention with a vehicle, 12 months state jail. 2010, possession less than a gram. He was given 2 years probation. The probation was revoked. He was sentenced to 9 months in the state jail facility. 2012, assault felony second. He was given 5 years deferred adjudication. Probation was revoked. He was sentenced to 3 years in prison. 2014, possession 1 to 4 grams. He was sentenced to 3 years in prison. And now we are here. All right. Anything you wish to say about your client's behalf?
Other than what I said previously, no.
All right. And state, you had something you wanted to say?
I did, Your Honor, but it's already.
All right. Anything you wish to say, Mr. Parau?
I am terribly sorry.
You want to raise your right hand for me? Do you
Yes.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
Quiet.
All right, you can lower your hand, state your name for the record.
Joshua Javier Pardo.
All right, you stated there's something you wish to say?
I'm terribly sorry for my behavior. I was on a reckless path. I didn't know. I also suffer from bipolar 1 disorder and PTSD. I wasn't on medication at the time. I have been trying to better my life for quite some time. My family is here in support of me. They have been very patient with me as well as I have tried to.
All
better
right,
my
I still don't understand why you went to the Dollar Tree and threatened the employees
I
and
went-
start breaking items.
Yes, ma'am. I went, I didn't have my glasses at the time. I tripped over something and I thought I heard her chuckle and, I lost my, subsided and took over. I knocked over, a stand, I believe probably $13 of damage. I was able to apologize to the cash, register woman and, she had told me that I wasn't allowed back at the store. I am on GPS monitor. I have been obeying everything.
Now, what it says in the stipulations, I'm not the one who accepted this plea, but what it says in the stipulation is that victim said suspect was verbally aggressive with them and that suspect verbally demanded money for an alleged recall of items from employees, victim 1 and victim 2 at the incident location. Suspect then started breaking items inside the store that were valued at approximately $13. Once he realized that he was not going to receive any money from the business. So there's nothing about you tripping over an item. It says that you went to the Dollar General, you wanted refund. They told you they were not giving you a refund. And then you proceeded to destroy items. And then you told them that you would shoot up the incident with the gun. So that's what you stipulated to.
I did say, Your Honor, that's why, that's why people ended up getting shot. But I did not threaten to shoot up the store. I have no way of getting a gun and, I'm not that type of individual to open fire or anything.
All right, the court is going to deny your application. The court is going to find you guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. Defense? The agreement is cap of 6. Do you want to speak to the cap?
I think based on the facts of this case, we've asked the court to assess 2-year punishment. Judge.
All right, the court is going to find you guilty. The court is going to sentence you to 6 years in the prison, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I'll recommend the therapeutic community for you. It doesn't increase the time that you're in custody, but it can help you perhaps with your mental health issues, any anger issues, or any drug issues that you have. You understand? I want you to know that I listened to everything that your attorney said. I reviewed the stipulations, even though I'm not the one who took the plea bargain agreement. And I reviewed the TAP evaluation, and I reviewed your PSI report. All right? So you're gonna have to start improving your life. You understand? All right, good luck to you. Court is calling 2024 CR 00899, State versus Noel Anthony Rodriguez. Mr. Rodriguez, if you'll come down, if I can have parties announced for the record for the state.
Robert Robot for Noel Rodriguez.
And are you Mr. Rodriguez? All right, you entered a no contest plea on October 16th, 2024 to the offense of choking. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 0088862. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, ma'am.
Any objections to the PSI report, state?
No objection.
No
Defense?
objections, Your Honor.
Have both parties had a chance to review the TAP evaluation, state? Defense?
Yes, ma'am.
Any objection to the TAP evaluation, state?
No objection.
Defense?
No objections.
Any witnesses, state?
No witnesses, Judge.
Defense, any witnesses?
No, ma'am.
All right. I'll hear argument then. State you're opposed?
We are, Judge. Given the defendant's criminal history, this is not the first felony that he's been committed or that's been convicted of. He has committed multiple acts of family violence, and one in October of 2023 was a choking and strangulation. However, that case was dismissed because the complainant waived prosecution.
And who was the complainant in that case?
It would have to check actually, Judge. He has been convicted of a lawful carry of weapon and assault in 2021, and I can check the victim on that one momentarily. He also has been convicted out of state, out of Wilson County for an assault second. He was given probation in that case. However, he did not complete his probation. He was revoked on December of 2023. And he is pleading to one case, which is the offense date of the 6th of June of 2024. It wasn't until he bonded out 3 days later, he committed another offense on June the 9th of 2024, also an assault second. Given his criminal history, given the fact that he has been given an opportunity to get probation in Wilson County, it has been resolved. The state does not believe that he would be a good candidate for probation, and we ask that you sentence him to no more than 10 years TBC.
Right. And while the state is finding the list of the complainant on the other cases, defense, I'll hear your argument.
Yes, Judge, defendant's been in custody for 168 days. He has no felony convictions that I know of. He has 2 children. He does need some mental health assessment. The complainant in the case, Megan Rodriguez, in the report states that she's in favor of probation. I think with the proper guidelines set forth and conditions that, that the probation recommends that he's learned his lesson. He's taken anger management courses, 12 of them. I'd like to give you copies
Any
of
objection
those.
to the court reviewing the certificates?
Okay.
So has spent his 168 days productively in custody and he's ready to return. He has to support his 2 children, needs to get back to work. And I think that any other conditions that you might give him that are outlined in the probation report, he's willing to follow follow your rules and not come back here.
All right, defense. I'm sorry, state.
Judge, to answer your previous questions on the first assault, the misdemeanor conviction was a different complainant. On the assault, choking strangulation that occurred on October 26th of 2023, where the case was dismissed for complaining waiving prosecution, was the same complainant as this case. It has a different last name, but I confirm it's the same date of birth.
All right, and then the case that you're taking in consideration, the ABI second, who's the complainant?
That one should also be the same.
All right, is there anything you wish to say?
I'm very more.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. All right, so what was this argument about?
I can't even remember that day.
All right, because according to the stipulations, it states that the complainant was sick through food poisoning, and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. She defended herself. You hit her in her chest, then placed your hands around her neck, choking her. So you don't remember any of that?
No, Your Honor, I was putting my daughter to sleep that night and she had been in the restroom. I was having difficulty putting my daughter to sleep and I had asked her to help me. She ended up picking up our daughter and she started rocking her, putting her to sleep after that. I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical that I was trying to leave. But at no point did
Well, it says here, the victim stated that she was strangled by her boyfriend. She sustained injuries to her neck and chest. While speaking with the victim, I observed scratch marks and redness to the left and right side of the neck and redness to the chest. I observed bruising to the left and right biceps and underneath both arms of the victim. And they photographed the injuries. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location.
I had cut my hair that day.
All right, well, in the report, they make it seem as though you choked her and then you cut your hair and then you left.
That day, it's hard to recall that day, but I know that when she had started choking me, and
Oh, so you're saying she started choking you first?
yes, ma'am.
Okay, you may continue.
After that is I started going back at her, and I regret it deeply. It's just
Okay. All right, any questions?
No, Your Honor.
State any questions?
Just a couple, Your Honor. Mr. Rodriguez, you are applying for probation or you're asking the court for probation. Okay. So you understand that the first step of probation is accepting responsibility, right? But when you spoke with the probation officer, when this report was being prepared, you did not want to talk about the incident, right?
I told the probation officer that I couldn't recall it fully.
Okay, so you did say that you had difficulty remembering, but then you also said that you'd rather not talk.
I didn't want to talk about it without remembering it fully.
Okay, but you do remember that she started it?
Yes, sir.
Okay. How is that accepting responsibility if you're blaming it on her?
I'm taking responsibility for my actions. I shouldn't have reacted the way that I did. I should just walked out of the house once things started getting physical.
But you understand that you've been placed on probation before, right?
Yes.
And the idea is probation should give you the opportunity to rehabilitate yourself and avoid engaging in any more criminal behavior, right?
Yes, sir.
So you didn't complete probation in Wilson County, right?
No, sir.
Okay, and then you committed an offense on June the sixth, right, of 2024? The choking,
Yes, sir.
and then again on June the 9th of 2024, right?
Yes, sir. Or, June 9th, that day I didn't really do anything. I had OD and my wife had called the cops saying that she needed ambulance.
No further questions, Judge.
All right, anything else from the
No,
defense?
I think, Judge, the fact that he took these anger management courses shows that he wants to comply with the terms of probation if you give it to him.
All right, the court is going to deny your application, find you guilty. Does anyone wish to speak to the cap?
Judge, in light of the fact he has two children, and he has a household that needs him, we request the cap be the minimum of 2 years.
All right, state, what are you requesting?
That's no more than 10 years.
All right. Mr. Rodriguez, I want you to know that I listened to the arguments of both sides. I listened to your testimony. I read the stipulations again because I'm not the one who accepted this plea. And I also reviewed the TAP evaluation and I reviewed the PSI report. This is what the court is going to do. Court is finding you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. Taking consideration 2024 CR 008862, there's to be no contact with Megan Lindsay Garza, no unsupervised contacts with minors. I'll recommend the therapeutic community for you. The therapeutic community does not increase the amount of time that you serve. For example, if I were to send you to 10 years, the fact that you're in the therapeutic community will not extend you beyond my sentence. Do you understand?
Yes, sir.
I do not have jurisdiction to force them to place you in the therapeutic community, so you'll have to request it. But it will show in your judgment that the court is requesting the therapeutic community for you to address any drug or alcohol issue or any mental health issues. And the court will sentence you to 6 years in the prison. Did you review the document? Yes?
Would it be possible to get the no contact order dropped?
No. And let me explain to you why. I don't like for people to think that I just do things just to do things. For example, because it's 6 years instead of 10, there's a reason for that. I took in consideration the mitigation evidence. I took into consideration what the complainant wanted, and I took into consideration your criminal history. And I took into consideration the classes that you completed. With regards to the no contact order, there's an issue here. And that issue hasn't been solved because this is not the first time that you were accused of assaulting her. This is the first time that I guess she's given a statement to the police about it and come to court about it and continued with it. So obviously that relationship is not working. I don't have you on supervision with the court because I'm sending you to prison. If I had you on supervision, I would still have the no contact order, then maybe slowly consider lifting the no contact order. But not in this case, the answer will be no. All right, so that's 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
You signed.
Yes. Your
All
Honor.
right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I know 6 years is a lot of time. It's a lot of time away from your children, but you can't continue to commit actions that you commit, violent actions, and then not expect there to be any consequences. When you're released from prison, if I'm still here, you need to make sure that you take care of your drug issues and you take care of your mental health issues. If you cannot find a place, come back here and I will pick up the phone and call someone to help you. You understand?
On my release, I plan on going to CHCS, Center for Healthcare Services.
Okay,
So
that's
I'm waiting to
great.
Get my primary care doctor back on vacation.
All right, awesome. Make sure that you stay on top of that, okay?
Judge Stephanie Boyd isn't buying Joshua Parau's excuse. He claims he tripped and lost his temper at a dollar store, causing $13 in damages. But the judge reads the stipulation. He demanded money, destroyed property, and threatened to shoot up the store. Then she does something devastating. She recites his criminal history spanning over 20 years, probation after probation, revocation after revocation. Parau pleads for mercy, citing mental illness. Judge Boyd listens, reviews everything, then drops the hammer. The court denies your application. 6 years in prison. She destroys his hope for freedom, proving that a lifetime of second chances has finally run out.
Here's a 3-minute, highly engaging AI outro for your courtroom channel. It's written in a dramatic YouTube style that encourages comments, subscriptions, and watch time while staying grounded in the themes of the case: criminal history, accountability, the judge's reasoning, and rehabilitation. As this case comes to an end, one question still remains. Was justice truly served, or was there still room for redemption? Today's hearing wasn't just about one mistake. It was about years of decisions, repeated chances, and the consequences that eventually caught up with the defendant. The court carefully reviewed the evidence, listened to both sides, considered the defendant's explanation, and examined his criminal history before reaching its final decision. In the end, the judge concluded that accountability had to come first. But now it's your turn. If you had been sitting on that bench as the judge, what would your decision have been? Would you have imposed the same sentence, offered another opportunity for rehabilitation, or handled the case differently? Share your thoughts in the comments below. We read every comment, and many of your opinions are featured in future discussions. Cases like this remind us that every courtroom tells a different story. Some defendants receive second chances and change their lives forever. Others continue making the same choices until the justice system has no option left but to impose a serious sentence. These real courtroom moments show how every decision, whether made inside or outside the courtroom, can completely change someone's future. Our goal is not to celebrate punishment or take sides. It's to bring you authentic courtroom proceedings so you can see how judges evaluate evidence, hear testimony, and make difficult decisions based on the law. Every case raises important questions about justice, responsibility, mental health, rehabilitation, and public safety. If you enjoy watching real courtroom cases, powerful sentencing hearings, judge reactions, and true crime justice stories, make sure you subscribe and turn on notifications. New cases are uploaded regularly, each with its own twists, emotional testimony, and unforgettable verdicts. Thank you for watching until the very end. Your support helps us continue bringing you real courtroom stories from across the justice system. Until the next case, stay informed, stay respectful, and remember, every decision has consequences, and every courtroom has a story worth hearing.